Welcome to another exciting episode of Legal Tech Briefs, and I'm your host Ankita. And today we have this episode of our podcast with our esteemed guest Armando. Armando, welcome to CaseFox. Please introduce yourself and describe your practice.
Thank you very much, and thanks for having me on. My name is Armando Riccio. I practice over in the state of New Jersey, representing employers both in the public and private sector. We're a mid-sized practice group dedicating to representing employers in the area of labor and employment matters. Personally, I have over a quarter of a century of experience practicing law in this specific area. And prior to going to law school, I earned my master's degree in personnel industrial relations. We pride ourselves on providing pragmatic advice as at the core of everything we do here when we're advising clients.
Okay. Armando, thank you for introducing yourself, and I'm so glad to have you on our CaseFox podcast. And so, let's jump right in. Armando, could you just please tell me the trends of labor and employment law currently, like which are in the discussion in the recent times?
Sure. As very recently, the hottest topics, we have a National Labor Relations Board at the federal level has become very aggressive under the Biden administration. It typically has a employee slant to it, but much more so under the Biden administration. And there have been several decisions attacking severance agreements, policies, and contracts alike. Also, both at the federal and the state level, state of New Jersey, pregnant workers enjoy greater rights than ever before. And both again at the federal and the New Jersey state level, the Department of Labor has certainly come out with a number of edicts or renderings that basically make it clear that you can't have an independent contractor in the state of New Jersey. It's an extremely narrowed class of individuals that can be classified as independent contractors.
Okay. Armando, how have the recent rulings by the NLRB impacted the employers and the day-to-day operations? I would like to know details about that.
Sure. So it's done so in a vast array of areas, and frankly, we'd have to spend over several hours to go over how significant the changes have been under the Biden administration. But as of late, there have been several key decisions attacking numerous employer practices and policies. For example, confidentiality provisions that you usually see in severance agreements. They have to be very narrow now. If you have a broad-based non-disclosure provision, it violates federal law, according to the present decisions coming out of the NLRB and the general counsel memos that are being issued by the NLRB general counsel. The reasoning behind them means that this and other decisions they've issued apply to much more than just, say, severance agreements. They'll apply to any type of contract that the employee may have signed, handbook or policy that goes beyond the limits allowed by those decisions. It'll likely be viewed as a violation of the National Labor Relations Act, which the NLRB is charged with enforcement and interpretation. So you need to make sure that in the private sector, because that's where the NLRB and the NLRA apply, in the private sector, you have to be cautious of confidentiality provisions. Of course, for our public sector employers, this really doesn't have any meaning because there are no confidentiality provisions in a contractor agreement with a public sector entity here in the state of New Jersey, where we're talking about the exercise of any type of governmental body action or the implementation of, say, a settlement agreement or a severance agreement. Those documents are public documents and public records anyway. But on the private sector, this has become a real game changer because, for example, the Stormy Daniels agreement and the non-disclosure provisions that were contained in that, according to the National Labor Relations Board, recent interpretations of its statute, those would be verboten from the very beginning, from the outset, so you couldn't have that. You also can't have non-disparagement clauses in the agreements and releases as well.
Okay. Like you told me about the non-disclosure contracts and everything. So it is the benefit for the both the employer also and the employees also in the private sector, right?
So yeah, in other words, the employer is not going to be able to pay a certain sum on a severance agreement and then say you can't discuss anything and you can't speak ill of me. The limitation on non-disparagement clauses are so narrow that the only thing you can preclude is defamatory statements, which, as a matter of law, an employee would kind of put themselves in a problem anyway, because the employer would then have a right and the resources to sue that employee for defamation. So having that clause in the contract is, a nicety. Of course, you're going to put it in there anyway, but that's really what you're narrowed down to. These broad-based non-disparagement clauses that say, hey, you can't say anything bad about the company. You can't go around saying that you wouldn't recommend us. Pretty much you can't say much of anything. Those clauses under the current NLRB decisions and the GC memo, General Counsel memo, are forbidden. They would be violations of the statute.
Okay. So, you mentioned pregnancy in the workplace. Can you tell us more about the protections and the changes in protections for pregnant workers?
Sure. Here, as well as several other areas in the law, employers have to be super cautious because the ground is literally shifting under our feet as we go along. It's not enough to comply with just the federal or the state law. You have to comply with both, and that can get pretty confusing. What's already water under the bridge, long since under the bridge, family leaves, for example. You have a statute at the federal level, the FMLA, Family Medical Leave Act, that'll apply to pregnancy situations and bonding. And you'll also have the New Jersey Family Leave Act that applies to bonding time. So you'll have both statutes, and sometimes those leave protections can run at the same time. Now what they've done is they've added additional rights that protect pregnant workers both at the state and federal level. It used to be in the state of New Jersey, the feds would pass something and lawyers representing management here in New Jersey would think, well, that's nice, but it doesn't really move the needle in the state of New Jersey because we've already had a law in place that is well in excess of what the feds are protecting here. That's no longer the case now with this administration and with the Pregnant Workers Fairness Act. They've added rights and requirements to accommodate a pregnant employee at the workplace, such as allowing for the expressing of breast milk under the Pump Act, under the Pregnant Workers Fairness Act. There's additional requirements as far as accommodations. You've got state laws also that you have to keep in mind that provide additional rights, such as many states, the state of New Jersey is one of them, has passed earned sick leave laws. And those statutes provide paid time off, not just unpaid job protected leave, but paid time off to employees. And you can't require the use of it as an accommodation for a pregnant employee. That could get you into trouble, not with the Pregnant Workers Fairness Act, but with the earned sick leave law in the state of New Jersey. It used to be that an employer could require an employee to use any paid time off that they had prior to the New Jersey Family Leave Insurance kicking in and the person collecting on the family leave insurance that they had contributed to. That's not the case anymore. Now the law had been changed back in 2019 that says that New Jersey Family Leave Insurance, the employer can't require the use of PTO before the employee is eligible, PTO meaning paid time off. As far as the Pregnant Workers Fairness Act that I was alluding to earlier, the state statute says reasonable accommodations are essentially based on the advice of a physician, and they can include a multitude of things such as frequent breaks, periodic rest, job restructuring, modified work schedules, temporary transfers, and unpaid time off. The federal version of the law is, being interpreted to mean significantly more than that. And what I mean by that is simply this. The federal statute, if you take a look at the real substance of the Pregnant Workers Fairness Act, past who it applies to and when it applies, etc., and get really to the meat and potatoes of it, it's only roughly about 2 pages long. So it's very limited wording. But the EEOC, which was assigned the responsibility to administer and to have oversight of the statute and interpret it, has come out with proposed regulations that are roughly 275 pages. The comment period ended on October 10th. We're waiting to see what it is that they finally adopt. But amongst other things, those regulations added telework, meaning working from home or remote work as an accommodation for a pregnant employee, reserved parking, like duty assignments, and suspending essential job functions, which is a real game changer because in the area of reasonable accommodations, typically you have to offer an accommodation reasonable in nature, that's not an undue hardship, that allows the employee to perform essential job functions. Here what they're saying is, hey, the accommodation for a pregnant worker can amount to suspending essential job functions. It does require also the granting of partial accommodations in the event there are some question as to what's reasonable and what's not. Well, if there's a portion of it that is reasonable and the employer isn't disputing, the employer at the outset has to grant that accommodation. There's also some verbiage in the proposed regulations, and we'll see what it fleshes out to be ultimately, but the proposed regulations pretty much say that, if an employer wants another opinion, is looking at another opinion, while you're waiting for a determination on it, you're going to grant the accommodation. Pretty much, it doesn't matter whether or not there's an undue hardship there. There's a lot more to these regulations. It imposes a great many more duties on an employer at the federal level than it does at the state level. You also can't select or impose upon an employee a reasonable accommodation, which is a real game changer as well. Under disability accommodations, both at the federal and state level, if an employer finds that there are multiple ways of accommodating somebody that are reasonable, the employer could pick which one of the reasonable accommodations it chooses that it's going to provide the employee so they can perform essential job duties. That's with a disability. Here, what they're saying is for a pregnant employee, they've got this heightened responsibility to the employee where they can't impose a reasonable accommodation upon the employee where multiple accommodations are available. And they also greatly limit the amount of medical documentation that an employer is entitled to for pregnancy accommodation. Keep in mind, they're talking about periods that can extend up to 40 to 42 weeks from what I remember from reading those proposed regulations. So it's not going to be an easy fit or an easy carry for a great many employers out there. The federal statute applies if you've got 15 plus employees within your employ. That's a great many employers that are out there. Stay tuned on what's to come on that.
Okay. So as the corporate world is changing, both the public and the private sector, these protections I think are needed. So all the employees out there are protected against all the discrepancies that are happening in the world right now. So, like as you mentioned, the New Jersey Equal Pay Act, how is it different from the federal law? Could you just please highlight a little bit of points which can tell our audience?
Sure, as is pretty common when you're dealing with a state statute or state law that covers some of the same or the same aspects as a federal law. The state law can't undercut it. In other words, it can't take away federal rights, but it can always build on it and make it more onerous for an employer. And here, the New Jersey Equal Pay Act has clearly done that in numerous ways. First of all, there's a 6-year statute of limitations. And what that means is that the employee has 6 years from the date of the violation to file a lawsuit. And they also made it so that every time you issue a paycheck that may be in violation of the Equal Pay Act, that causes the statute to run anew, which means it could perpetuate itself continuously until the defect is cured. Now, what the statute provides is it prohibits pay of a protected class member for substantially similar work. Now, when you look at that and compare it to the feds, the Federal Equal Pay Act was limited to sex, and it was limited in terms of equal pay for equal work. Here we're talking about substantially similar work, so it doesn't have to match on all fours across the board. And under the state statute, what they look to is a composite of the skill, effort, and responsibility. So your job description, your job title is irrelevant. What it comes down to is what are the core job functions and job duties that are performed by the two individuals, and is one member of a protected class when compared to others being paid differently. And if they're being paid differently, the onus is on the employer to establish as a defense, not the employee to establish in the first instance that there's a pay discrimination, But if they show that they've got their member of protected class and they show that they're performing substantially similar work, well, then what you've got to look at is, hey, can the employer establish the defense that there's, say, a seniority system in place or a merit pay system that's in place that accounts for all of that differential? If not, then they've got 5 factors that they've got to establish as true. And that comes down to that it's based on one or more legitimate bona fide factors other than protected class, such as the person's training, education, or experience, the quality or quantity of production. And those are factors that employers, unless they've got a system in place measuring quantity or quality, measuring what it is that the employee is doing, or has some ability to quantify it, they're going to have difficulty making out that component part. You can line up training, education, or experience, but sometimes I've found in representing employers, you look at the resumes and compare the training, education, and experience from person to person, and the employer falls short in these areas. So making sure that your pay structure is in line based on training, education, or experience, and if not, doing your own self-audit in this area right now is really something that's a proactive approach that can keep you out of the soup at the state level. The second factor you have to meet is to establish factors or factors that are not based and don't perpetuate difference in compensation based on sex or any other protected characteristic under the law. So that could be race, creed, color, religion, sex, sexual orientation, gender identity or expression. Those are all protected classes under state law. You have to show that each factor is reasonably applied and that one or more of the factors account for the entire wage differential and that the factors are job related and consistent with business necessity.
Okay. I was very curious about this one question. Like, since I have heard it and read it on many places and blogs, like, what are your thoughts about the ever-growing impact of the legalization of cannabis in the world of workplace?
Yeah, so cannabis here in the state of New Jersey has been legalized, which I'm smiling at because I still haven't figured out how it's legal. They can legalize something at the state level, and
Yeah.
yet it's illegal at the federal level. That just comes down to an enforcement issue. Anyway, be that as it may, when we're talking about cannabis in a workplace, our state statute provides no safety sensitive exceptions, not for police, fire, EMS, lifeguards, none of it. There's an AG guideline out there that cops assigned to certain duties can't use cannabis, and it's very narrow in scope, and it usually involves the interplay with federal operations. But it is very narrow. Otherwise, police are not prohibited as well. The only limitation is someone that's a CDL holder because that's governed by federal statute and federal Department of Transportation DOT standards, and they're subject to random testing, and that includes cannabis-based testing. Other than that, the testing here is really limited to reasonable suspicion testing. Now, when we're talking about testing, I want to make sure that we're clear on this. We're talking about cannabis. This does not mean you can't do post-offer pre-employment drug testing for the other 9 out of the 10 panels that are usually tested on a post-offer pre-employment drug test. But cannabis here, it makes little sense to do it anymore because you can't take it into account in whether or not you're going to hire, fire, or discipline somebody here in the state of New Jersey if they're a user that's off duty. This does not forgive or allow an employee to use cannabis-based products and come to work high or still under the influence. That is still forbidden. There's a great many issues that we're still working through, such as, for example, formulating whether or not there's reasonable suspicion based on observed behaviors. Employers have to have 2 managers trained, and those individuals have to complete paperwork. My recommendation is that you do that prior to having the person tested, because otherwise it's too easy for the plaintiff side, the employee side, to come back and argue, well, you got this test result that shows positive, and then all of a sudden you fill out this form to say, oh yeah, there was suspicion. Interestingly enough, the Cannabis Regulatory Commission that issued that memo didn't turn around and specify when you should be doing it and what the order is. I'm assuming that they just assumed reasonably that you should be filling out that paperwork before you send them for the test. The other thing is that the statute says it's supposed to be performed by a workplace impairment recognition expert. That entire program was supposed to be put together by the Cannabis Regulatory Commission. They sidestepped that, issued a memo saying train 2 managers. They don't tell you where to get the training. They don't offer you substance as to what the training program should include. I do caution employers in the state of New Jersey here regularly, make sure that they use a solid program that has a minimum of a 1 8-hour class, and that is a bare minimum, because that is really where the attack is going to come from. The statute allows for the drug testing, even though we already know that the drug testing is not really 100% reliable. It has been narrowed. I think there's one set of tests that can narrow to a 4-hour time frame, but it still doesn't tell you whether or not the person is, under the influence at the time, unlike alcohol testing. Now, as many of your viewers has probably guessed, my practice is, devoted to an area that's constantly changing. So we really don't need added work on the administrative side of the fence, which is why we count on CaseFox for my practice. It's intuitive design, it's easy use, make it a no-brainer, and it's priced at a highly competitive price point, and that makes it a go-to resource. So my firm certainly recommends that if you're considering changing billing software or looking for it for the first time, definitely do a walkthrough on a CaseFox program. It's certainly worth the time.
I'm so thankful that you had such great feedback for CaseFox, and I'm so glad that we are having this podcast. But for the last question, I was very curious about the cannabis legalization at workplace. So, on the personal level, like, what do you think? It's the right thing or the wrong thing that is legalized from the state but not the federal law?
Yeah. Look, I'm not in favor of legalization. It's not something that I believe is a smart move for us. But at the same time, I also am sensible enough to recognize that, I am voted down on this, hands down. The vast majority are in favor of it. For people to say, or for them to espouse that this isn't a gateway drug, again, I think they're horribly wrong there. I grew up in New York City. I grew up in a neighborhood where it had become pretty rife with heroin and cocaine. And it started out with something as simple as marijuana. And once you get past the whole feeling of, I shouldn't be doing this, that I know from personal experience with individuals that I cared deeply about that were friends. I've lost people that have started out simple enough with that product, and it made them comfortable enough to go out and start experimenting with other stuff. I don't know that anybody even knows the name angel dust or mescaline, but those were pretty popular when I was in my teens. How am I going to now explain to my daughter, who is all of 6 years old, the significance of messing around with that or going any further than that when you've made it so it's treated with the equivalence of saying having a beer. I don't believe the impact is the same. You can drink a beer and walk away from that and get behind the wheel and you're still okay and do other things without it turning out to be a problem. You can't smoke a joint or do an edible and go to work or get behind a wheel. You're not going to convince me that those two equate. They don't. They
It's
just
very
don't.
risky.
And the impact, I don't know what's going to happen long term. Who knows? Maybe we're going to see some of the results here. I certainly don't wish anybody ill, but sadly, I think we're going to end up having to live through some horror stories before we recognize. And I don't know that you're going to be able to reel this back any. I don't know that you're going to be able to take that step back. Here in New Jersey, you rarely would smell marijuana, and on a regular basis, you walk down the street now, and you know, there isn't a place that I can go that's populated because there's a show, because there's some event you're attending, or it's a popular location where you don't smell it in the air now, everywhere, and we'll see what happens long term. Hopefully, people, much like with cigarette smoking, will wise up as to the long term impacts it's going to have on them health wise. There are multiple studies, and I know we have a distrust of the government, a healthy distrust, I might add, because our government has said some stupid things, but and stood by some stupid things. But at the same time, you know, I don't doubt that the linkages that are being drawn to things such as Alzheimer's is when it comes out of private sector industries doing these tests and coming out with these results. I don't doubt that there is going to be those ties there.
Okay. I'm sure that definitely, since it's not legalized by the federal law, definitely the state law will someday recognize it and will do something about it. I'm sure about that. So I'll just conclude the podcast, and I am so thankful that you joined us today, Armando. And if our listeners are as thrilled as we are and want to connect with you or your team, how can they embark on this journey together?
So if you wanted to reach me, again, my firm is dedicated to representing management, corporations, municipalities, townships, and their members of management. But if you wanted to reach me, you can reach me at A Riccio, that's RICCIO, at njlabor.lawyer. That's A Riccio at njlabor.lawyer.
Okay. Thank you so much, Armando, for joining today. And I'm so glad to have you on CaseFox podcast. And we will definitely have you in future as well.
Thank you. And I'd welcome the opportunity. I appreciate the opportunity to be on here today. You have yourself a great day.
Yeah, you too. Thank you.